surface matter is trace matter. Petitioner is already deposited all the outstanding. Issue the vacation is tomorrow yours. Vacation 9 years custody.
Face admission surface matter. Face admission surface matter. But tomorrow.
But appellant custody for 18 years.
19 तारीख लिस्ट पे थिला पड़ी करना
फाइनल डिस्पोजल में तो
ना बेल
बेल
काली
काली आगे हम होमस्टेड बिल्डिंग टा वेकेट कर देबे काली होमस्टेड बिल्डिंग टा
मैंने काली ऐसे ओवर कॉल
Mining adjourned to be delisted on 27/25, but the matter has not been listed yet.
व्हाट इज द मैटर
JCR is 66 of 7.
बेल बेल में
Yes.
I wait for pardon my item number 10.
कौन
I will also cancel taken up after which comes.
यू आर फॉर द
Union of anyone. My lord, and is appearance of
you are supposed to file an application for amendment
yes, my lord.
but you have not filed.
Number
Just a minute.
Order number 2, madam.
Right, Mr. Saubhagya Chandra Devdas, Central Government Council, sits for an adjournment to file the interim application for amendment as per the order dated 25/6/2025. What is your good name?
I'm on behalf of AK Vera, man. On behalf of
You are A.K. Vera.
Yes.
Mr. A.K. Vera and counsel for the opposite party is present. Put up this matter. Take after puja. Yes.
Diplomat.
Supplementary list. Item number 1.
302 yes.
face admission.
302 to?
Again. Enter 307H. 307.
(302) and 307 only. All right. All right. Move call for the trial. You wish to engage? Yes, not.
Item 2.
My lord, can it be after vacation, my lord?
Paril and solicitor general. इसके सामंत्र है
ऐसा मंत्र है
सामंत्र सेंट्रल गवर्नमेंट काउंसिल तो
जी से आ गया जी सेंट्रल गवर्नमेंट काउंसिल
गवर्नमेंट काउंसिल कुछ फॉर एन एजेंडा आपको पूजा होगी yes ma'am yes next
Item 3.
item 3
I'm for the petitioner in the second item.
In this case, my lord, till date, my lord, the petitioner affect
you
and they are not
time the last date
my lord.
to file the entire pleadings which were there before the land and central administrative
I
court.
filed mine. And that
So what is the challenge in this petition? Order dated 24/10/2024.
my lord.
That is annexure is 12.
My lord, in this case, my lord, on the basis of ornamental language, the benefit of the petitioner seriously affected till date. The 19 technical
What
rules.
was the prayer in before the?
My lord, tribunal, the same prayer in tribunal prayer, Honorable High Court, the writ application prayer, all prayers same mandate. That's
What
the
the prayer thing, not the same prayer, same prayer.
Prayer is there.
We should pass the memorandum also and directly.
The Honorable Court used to admit the writ applications. The tribunal,
You say that what is the prayer, your prayer before the relief short for Basundu, paragraph number 8 there. Direct the respondent to respondent number 1 to clear the application. In 3 to 3, in time scale of also it is like from 1/10/1975 is all consequences of the past, including the promotion. What is your status now? These two appellants have already been retired. The petitioners have retired from service.
my lord, already died, the legal answer.
And two is also dead and so many persons have come out. So why are you seeking for a relief that your what is the explanation for delay? Because you want the time scale will effect from 1/10/1975 with all consequential service benefits. So for that, you approached the tribunal in 2007. Yes.
Are you prepared or not? Are you ready with the matter?
After
You simply tell that you are not ready here. Here is what is it? What you are saying.
May I comment few lines, my lord?
He is not ready. That's the lead matter. He is not ready. You prepare. Don't take chance like this.
Yes, next.
Item 4.
Open number 2 and 3. In this case, I am open number 2 and 3.
May I please, my lord? Well, also kindly give a glance in my last order dated 24th April 2025. May. I'm placing my lord. The writ petition has been filed by the petitioner also goes challenging the order dated 24/9/24 passed by London Central and Terminal Court Court in order number 732 of 2012 in dismissing the original application. It is the contents of London Council for petition that the original application filed by the petitioner in order number 732 of 2012 was adjudicated on merit at the first instance by the London Central and Terminal, and a final order was passed on 22nd April 2022 dismissing the original application, and the said order was challenged before this court in WPC number 16429 of 2022, and this court had order dated 22nd February 2023, set aside the order of the London Tribunal and remitted back the matter for press disposal, and thereafter, the petitioner filed an application for amendment of the original application, which was allowed, and the contrary original application was filed before London Tribunal, and copy has been served on the London Council for opposite parties, but no additional counter affidavit has been filed by the opposite parties, though they had earlier filed the counter affidavit prior to the amendment, and therefore, the amendment portion of the amendment taken in the original application has remained uncontroverted. He urged that the London Tribunal has on its own stated so many things in the impugned order without taking note of the amendment portion of the amendments and dismiss the original application. Since the application filed by the petitioner for amendment, the order allowing such amendment.
Come to paragraph 7 of the impugned order. Next to 10. Page 60.
Mela.
Yes, read it on.
Insofar as the prayer to direct the respondents not to dispense with the contractual engagement.
Not to dispense with Contractual engagement. Yeah.
is concerned, since his service had already been dispensed with and in absence of any such prayer for his regularization, the prayer is automatically made redundant. Full stop. Insofar as the prayer for applicant for quashing of his order of disengagement retrospective had order dated 9/9/2020 with effect from 1/9/2020 is concerned, according to the applicant, in terms of Government of India memo dated 23 March 2020 issued during COVID-19 pandemic, it has been clarified that wherever any contractual, casual and outsourced staff of ministerial department and other organizations of Government of India is required to stay at home, they shall be treated as on duty during the such period of absence and necessary pay/wages would be paid accordingly. Full stop. This circular has no application at all to the case in hand because a contractual appointee does not have any accrued right to claim for his continuance when such appointment was made adheres the rules, especially beyond the maximum age limit fixed by Government of India for entertaining into government service.
Entering into the government service.
Admittedly, the contractual engagement of the applicant was extended from time to time, obviously, taking into consideration the need in the hand of the department. Full stop. No document has been produced by the applicant to substantiate that though his contractual engagement was in force when he was disengaged retrospectively during the lockdown. Full stop. The applicant has also not produced any document to show that the lockdown imposed by Government of India / State of Odisha due to COVID-19 pandemic was in force during his disengagement. Rather, this tribunal have come across with the orders of Government of India dated 29/8/2020 and Government of Odisha dated 31st August 2020 when the process of unlock had started. Full stop. The dispensation of service of the applicant from his contractual engagement was not due to remaining absent from duty for the lockdown due to COVID-19 imposed by government. Full stop. The dispensation of engagement of applicant was purely aristocratic in nature and was ordered from 1/9/2020 by the order dated 9/9/2020. Full stop. It is not the case of applicant that he was in service from 1/9/2020 to 9/9/2020. Full stop. Therefore, the stand of the applicant that the order dispensing with his contractual engagement retrospectively is not sustainable does not appeal to the judicial consent. Full stop. It is also well settled law that there is no vested right of a contractual employee to claim for his continuance or regular scale of pay. Full stop. The applicant is well aware that he does not have any right to seek regularization in view of the discussion made above, therefore, he has made an endeavor to virtually get the said relief alternatively in case any such direction is issued for granting him regular scale and his continuance on contractual basis, notwithstanding the well-settled law that what cannot be done directly, cannot be done indirectly. Reference Subhash Chandra versus Delhi Subordinate Service Selection Board, 2009, 15 SEC 458. In before the discussion made above, we find no merit in this way, accordingly, which is accordingly dismissed by leaving the party to. So my submission before my lord, I made a specific argument in the way by challenging the order of disengagement, but there is no denial. So far, 2 letters of order referred by the court, that is so much mild, because there is no dispute. So far, my continuance in service from 1/9/2020 to till 9/9/2020 is concerned mild. Because the present opposition parties, they have not filed any counter after my amendment mine. Your lordship directed me to file the orders. I have filed my orders of the law tribunal showing that amendment allowed in their presence, time granted, last chance granted for filing additional counter. In spite of that, they did not prefer to file any additional counter.
Which part of the amended which part of the amended way you have taken that ground?
Mine.
So as
That is not factually correct, your lordships. We have filed an objection to the petition filed by the application of amendment. That is also there on record, your lordships.
no, what he says that after amendment, you have not filed a additional counter controverting his contention.
No, we have not filed.
Might have done it, but it was allowed.
Yes,
Thereafter amended, and the amended portion you have not controverted.
My lord, I have
What he says.
filed copy of a considered way. Your lordship kindly
Where
give
is
it
Where is that? Consider it.
along with one memo. My lord, I have filed that is nothing. I have filed.
Which paragraph you have stated that, which of the OA?
Page 11, my lord, 4.13, 4.14,
4.13.
13. 14, 15, 16 and 17. These are added. Paragraphs we have added by your amendment.
413, 414,
My
415, then
460.
416.
413 to 460.
Next one. On practically other con ଲେଖିଛନ୍ତି ଆପଣ?
ପଢନ୍ତୁ 13.
13. That when the counter statement is outed and show of date, no such copy has been ever so respondent issued an email to the applicant on 10/9/19 indicating termination service of the applicant and are not assigning duties. For kind perusal, a copy of order dated 9/9/2020 is annexed here. Are not extended with effect on 1/9/2020 with retrospective effect. The impugned order is void of issue and grossly violative of principle of natural justice. Full stop. Law is very well settled by the constitutional bench of Honorable Appeals Court that there cannot be any retrospective termination/dismissal. Full stop. The retrospective termination is void of issue and is contrary to settled position of law. Paragraph 15. That the impugned letter lacks reasons which the respondent are legally bound to indicate. Full stop. No semblance of reason has been assigned, far less any legal, valid and plausible reason at all. No notice to show cause has also been issued to the applicant. The respondents indicated that salary from July 29 till August 2020 is being released, but in fact not been released. When the basic right to leave is being taken away the minimum requirement of issuing a notice has not been followed. Hence, the impugned letter is violated of Article 21 of Constitution of India form. Further, when civil right is being obliterated, prior issuance of notice is mandatory. But no such notice having been issued before sending the impugned email, the impugned annexure A by 12 is liable to be quashed. Further, settled administrative law is that component of impugned order shall have to be served on the affected party. In the instant case, the respondents withheld the order of the competent authority and did not communicate it to the applicant, it also does not form part of the order. Therefore,
So it is up to 4.16 or 4.17 also. You see,
17 also. 413 to 417.
okay. And the respondent or the opposite party, they have not filed any counter to this.
Your lottery directed me to produce all the orders. I have filed one along with the amendment.
Where is that?
My lord, that is starts from page 22.
All of.
Page 22, 23, 24 and 25.
Which order you have gone to?
Oh, additional counter file करे someone नहीं चल.
Again. Last one दिया इतला.
Last chance होची नहीं last order टा होची अपन करो
25 दिन 21 रे.
25 दिन 21.
Again.
ये order के भी पास ला जो impugned order.
Impugned order पास है ची 24 में से.
आउ तापरे matter list आसीनी. आसी किन file करना. And whether that has been mentioned in the order itself that no counter affidavit has been by filing. अच्छा है तो लिखा होची उटा paragraph 4 रे respondent by filing the counter affidavit contested the case. तो गोटे लिखा होची paragraph 4.
Counter they have filed before amendment.
Original.
That counter I have enclosed as annexure to my writ petition.
Okay, but this additional counter affidavit they have
not.
Then your case is if amended portion of the OA would have been taken into consideration.
Then my order
the result outcome of the OA would have been different.
Moreover, in this case, I have continued for 16 years of service and represented state of Odisha and government of India in so many international events. Instead of that, I am in the vacant stand.
Or the
if your lordship permits me, I would just like to bring a couple of things before your lordship perusal. Your lordship will come to annexure 1 and 2. I think your lordship will be amply clear what the case is.
You file the counter.
Is to be like on the petition has been filed by the petitioner Ashok Ghosh, ex-archery coach, Sports Authority of India, to set aside the order dated 24/9/2024, passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 732 of 2012, and for a direction to the opposite party to allow him to continue by regularizing his service. The Land Council for the petitioner submitted that the petitioner filed the aforesaid OA inter alia for a direction to the opposite parties to impart regular scale of pay as admissible and as has been given to the similarly situated employees of SAG SAG centers without dispensing with the services of the petitioner, and to quash the later dated 9/9/2020 and direct the opposite parties to grant consequential service and financial benefits. After issuance of notice, the opposite parties entered appearance and filed a counter affidavit. However, thereafter, an interim application was filed for amendment of the original application, and the prayer was allowed, and a consolidated original application was filed, in which paragraph number 4.13, 4.14, 4.15, 4.16, and 4.17 were added. To the opposite parties took time to file additional counter affidavit to the amended original application, but no such additional counter affidavit was filed. The Land Council further submits that since the averments taken in the amended, in the consolidated original application from paragraph number 4.13 to 4.17 have not been controverted, if the London Tribunal would have considered the same in proper perspective, the result of the order would have been different. But unfortunately, without considering the averments taken, the impugned order has been passed, which is therefore not sustainable in the eye of law. Issue notice on the question of admission, indicating therein that the matters have been disposed of at the stage of admission. The Mr. Pari, along with
Ashutosh Mahanti,
Ashutosh Mahanti,
Land CGC, CGC.
Central Government Council,
Aଜ୍ଞା, CGC.
Central Government Council. ଆପଣ ସ୍ପୋର୍ଟସ ଅଥରିଟି ପାଇଁ ମଧ୍ୟ ଆପଣ appear କରିବେ ତ? Submits that they have instruction to appear for all the opposite parties. Let extra copies of the writ petition be served on the Land Council for the opposite parties. Matter be placed 4 weeks after. Counter affidavit, if any, be filed in the meantime. Yes, next.
Item 5.
The petitioner logging continuous service for 16 years. That is service has been discontinued without any reason whatsoever. Yeah.
Yes, reasons. You know, this present lead application, we prefer, my lord, the order passed by the OERC, my lord. You know, the facts of the case is now there are 2 units. Petitioner has 2 units, man, in different locations. And there are 2 separate distinct agreements between the authorities and the petitioner for supply of electricity. So in the year 2001, the power supply to one of the unit was disconnected.
You know, which order you are challenging?
And then, my lord, Annexure 27, page 239, my
27.
my
39.
Annexure 27 is the
order passed by the
case number 42 of
again,
2024.
again.
So it was passed on 12/11/2024.
No. No, this order was passed based on the report.
No, please come to your prayer portion. Where have you stated that you are challenging that order?
Yeah, my lord, I prayed for that the demand letter has been issued.
Mr. Counsel,
My lord.
an order has been passed against you and you are telling that you are challenging that order.
The order, my lord, not exactly the operating portion of the order.
This order is passed.
No, I'm not
on-
agreed by this order. By the
So are you not supposed to challenge this order? If
No,
you are
no.
aggrieved by this 12/11/2024.
no, not agreed, my lord.
Then
Because the order has been passed to abide by the report of the ombudsman. The OERC has passed the order where a direction has been given to the board.
come to the order.
My lord. Well, paragraph 7. After going through the report of the arbitrators in the present case and upon hearing the parties, we observe that the arbitrators have considered all the aspects of the disputes and concluded with judicious findings. Therefore, we direct the concerned parties to abide by the report dated 6/11/2024 of the arbitrators in the present case and act accordingly to resolve the dispute. The said report dated 6/11/2024 of the arbitration pertaining to the present case does form part of this order.
So now, if you do not challenge this order, then the order stands as such.
Well, the order which has been passed, the arbitrators report, my lord. The arbitrators has
Mr.
directed.
Counsel, who has approached the?
My lord, I have not challenged this order. They have not. This direction passed by the OERC, the opposite parties are not revising the bill, my lord, as per the report of the arbitrators. And they have demanded the same amount as previously they have demanded the same amount and this time also. They have not revised the bill as per this direction, my lord. That is my
What
grievance.
is that report dated 6/11/24?
My lord,
Annexure 26.
26. Starts from 231, 233, the report starts. Page 200.
So what it says?
What, my lord, your lordship may see the last paragraph, the 3 points to the arbitrators found whether there is justifiability of clubbing the normal charges.
Where are you reading?
My lord, 1, page 233,
233, yes.
1, 2, and 3, bottom, my lord. So these points, my lord, whether there is justifiability of clubbing the normal charges of electrical dues with the penalty amount. Whether there is justifiability of imposing of surcharge in the nature of delay payment surcharge over delay payment surcharge. Whether the amount offered by the petitioner by way of one-time settlement proposal averted by the petitioner on dated 10/3/20 is acceptable and sustainable in the eye of law. My lord, by dealing these points, my lord, your lordship may see at page 235.
Yes.
Serial number 7, after serial number 7, my lord, the paragraph, next following paragraph, my lord, it is evident. कितना हो गए? 235.
235.
It is evident that the penal bill and the charge leviable due to slowness of the energy meter are different and cannot be logically clubbed together. Since the bills raised against the petitioner do appear to be penal bills, the code then prevalent, Distribution Supply Code 1990, was binding to the parties. The answer to the above point goes against clubbing of the entities. When we're dealing with point number 1, they have observed that you cannot club both the bill, penal bill and the bill, which they had done earlier, my lord. So this portion and another, my lord, the next point number 2. So after taking into consideration the provision of law, my lord,
So
second last.
this is in your favor.
My favor, my lord. What they have done is after this report, my lord, the OERC have passed the order. Your lordship has seen that order.
OAIC says that you follow the order.
Follow the order. So they have to recompute and revise the bill.
So that they have not done.
That they have not done. They have issued a demand notice on Annexure 29, same amount, my lord. That is my grievance, my lord.
All right. The petitioner, Utkal Graphites Private Limited, has challenged the demand letter dated 28/1/2025, raised by 28 or 27.
28, page 247, my lord.
247 the
Annexure 29.
20.
ऊपर 40
28.
अच्छा 28/1/2025 is executive engineer रायगड़ा इलेक्ट्रिकल डिवीजन TTSODL রায়গড়া এটা কত নম্বর অপোজিট পার্টি
এক্সিকিউটিভ
পক্ষে করছেন না না
আগে three
opposite party number 3.
So it is contrary to the arbitration.
In raising a demand of rupees 8 as 1 crore 40, 1 crore 40 lakh 57,246. The Land Council for the petitioner submits that earlier a demand was raised and the matter was referred for arbitration, and the when that arbitration 26 and the ombudsman to arbitrator formulated three points for addressing the submission of the award, which are as follows. Quote kar dege. 1, 2, and 3 in page number 233. It is stated that all the points were decided in favor of the petitioner, and the arbitrator held that the petitioner may be saddled from date of liability to clear the bills as per the changed code, that is regulation 150 of OERC code 2019. And
by adopting this principle, charges of unjust enrichment by either side shall be warded off for better consumer licensee relationship. And it is further held that the DPS may be levied only after the bill has been issued against the consumer and the consumer is found to have not cleared the billed amount. It is further stated that the matter was carried to the Orissa Electricity Regulatory Commission in case number 42 of 2024. At the instance of the key, kaha year jaitla seta 37 लिखाई जी हाँ at the instance of the petitioner and it has been held by the VRC that arbitrator has considered all the aspects of the disputes and concluded with judicious findings. Therefore, the concerned parties are to abide by the report dated 6/11/2024 of the arbitrator and act accordingly to resolve the dispute. The Land Council argued that in spite of such a report of the arbitrator as well as order passed by the VRC, the demand notice dated 28/1/2025 was raised without revising the bills in terms of the finding, rather reiterating the previous demand, which is not proper and justified. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. So, is it necessary to issue notice to the opposite party number 1? Because your main grievance is against opposite party number 3, it seems. No notice be issued to opposite party number 1. Requisites for issuance of notice to the opposite parties number 2 to 5 shall be filed by within 3 days for them. Hello? Matter registered on such and such date. Now I hear issue notice for them, one set of process people. Yes, next.
Item 6.
Mr. Amitabh Das is not here. Yes, sir.
Last Pakistan Lordship has directed me to check up the law of statutory provision in this because the employee under suspension was allowed to retire without any objection and proceeding. After retirement, the proceeding was initiated, madam. And the authorities have held up his pension. The Central Administrative Tribunal has rejected the same, relying on the some judgment, madam, which are overruled.
The operative part of the order which we passed on that day,
Yes, ma'am.
23/6/2025,
Yes, ma'am.
is that once so system time, senior panel counsel, so and so, we filed some citation on the point that even if the opposite party was
Yes.
under orders of suspension and was allowed to retire on attaining the age of superannuation without any objection and without any initiation of departmental proceeding, and thereafter the departmental proceeding is initiated against him by the petitioner, the opposite party would not be entitled to his salary and allowance with effect from his date of suspension as it spent on duty, and such payment would be subject to the result of the so and so. What are the decisions?
So decision that I have taken, only statutory provision.
No. You said that we have.
This
seen
is
that
not-
has been discussed.
This one I have gone through.
You're
madam.
not able to found, or you need some time?
Get some time. That
One
is, the
decision.
order is 3-page order and everything has been stated
Yes,
there.
yes, I have
Good time.
Let your junior find.
Yes.
The learned Mr. Das and senior advocate seek some more time to
One.
show some citation on the points as per the order dated 23/6/2025, put after ensuing puja holiday. Yes.
One development has taken place. In the meantime, madam, the CAT has moved, they pass an order in the content petition matter. Either you brought a stay order from the court or you comply the judgment. That is there, madam.
We will come prepared, we'll see that.
Till
Yes,
then,
next.
till then, madam, no order should be passed.
It is going to happen. Yes, next.
Item 7.
Otherwise, madam,
No, this order was passed in 23/6/2025.
Yes, madam.
3 months have passed. You have not collected any
No, no,
decision, not found.
no.
So now you are telling that the
judgment-
content petition should not proceed.
The judgment which I have collected, madam, is against me, madam.
It's all right.
Then
As a senior advocate, you
Yes.
should also show that.
In one case, madam, the division bench is allowed, saying that the time limit of will not apply since the sanction of the president is there.
Why
The Supreme Court has turned down that.
You advise your client properly that the cases are, the
No.
judgments are against us.
Yes.
So you better to abide by the order of this one, so nothing will happen there.
Madam, your lordship may, madam, direct that to conclude the departmental proceeding within a time limit, madam. Dispose of the
Let it come after puja holiday, we'll see that. Yes, next item 7.
Only they should not proceed, madam.
You comply the order and come and tell us that this has become infraction.
We have complied.
That's the best way.
Madam, authorities are facing problem. Your lordship dispose it up, we will comply, madam. Your lordship dispose it up, we will comply, madam.
Acha, the learned counsel for
Yes.
the Mr. Das submits that he has taken instruction that the petitioners shall comply with the order dated
No.
26/7/2025 passed by the.
Madam, dear lordship,
Sorry?
comply. Lordship pass order that the
No. I will. You
Merit-
said from your side, we will dispose of it.
on merit, your lordship may dispose it.
No, then merit, you show the citations, otherwise we'll dismiss on the admission stage. Yes, next.
8th, madam.
Yes, next.
Item 8.
7 chronology.
Item 7.
Non appears after puja holidays. Yes, next.
Item 8.
Mr. Deepak Gochai. କଣ ଟିକେ ବଡ ପାଟିରେ କୁହନ୍ତୁ after ପୂଜା holidays next.
Item 9.
Order dated 2/7/2024. That is at Annexure 6 is the subject matter of challenge. So this on the court. This order is passed by the learned CAT, Central Administrative Tribunal, wherein the order passed by the disciplinary authority. You have filed this
Copies of
copies of the OA, counter affidavit, etc.
That was the direction.
Direction ଥିଲା ସେଟା ବୋଧେ ମୁଁ ଅନଲାଇନ ରେ ବୋଧେ କରିଦେଇଛି, I do not remember exactly. କିଛି ନାହିଁ ଏଠି ତ ନାହିଁ କିଛି. Take instruction whether you have. I have that documents, but no, you should file it. There is a specific order, and we insist that the pleading should be brought before this required. The entire pleading for a better adjudication of this. Tomorrow, the learned counsel for the petitioner submits that he has to obtain instruction whether the order dated 25/6/2025 has been complied with or not. So far as my instruction matter, it has not been complied. ଏଠି ନାହିଁ ଯଦି ଫାଇଲ କରିଛନ୍ତି ତାକୁ ଟ୍ୟାଗ କେମିତି ହବ ଦେଖନ୍ତୁ ତାକୁ. After ପୂଜା holidays next.
Item 11.
Date may be fixed. ये date संध्या ବେଳେ ଦେଖିଦେବେ.
Item 11.
I am to the respondent matters. Bank.
Is for the appellant Arun Kumar Mishra. Non appears for the appellant.
You are appearing for whom?
The bank, nice.
All associate. The learned counsel for the respondent is present out of this matter after ensuing puja holidays. Yes.
Item 12.
prayer for restoration of petitioners.
Connection of delay होची 477 दिन. Notice ଯାଇଥିଲା. Appear to colony.
All are the government petitions.
State of Orissa. Engineering in chief. So these are for state all these. कौन है the file करी ना नाइक ना delay कौन करी. कौन क्यों? The learning counsel for the state 477 दिन अच्छी delay. 6 some more time to file objection to the interim application for condonation of delay for this matter after ensuing puja holidays. Objection, if any, be filed in the meantime, serving copy on the land council for the petition. Yes.
Item 13.
Because on what time to be. Hospital certificate and no certificate.
Premature release finally, well, and council for the state 6 some more time.
I see.
Premature release. The land council for the other Kejon appellant ଅଛନ୍ତି. ये କାହାର ରିଲିଜ କରିଛନ୍ତି? ଜଣକୁ ଦେଇଛନ୍ତି ଓ ଆଉ ଜଣ ଦିଟା ଅଲଗା
Prescar.
Custody being on extract portion of the sentence limited by the or of the government.
এটা হলো হরি, এটা হচ্ছে
Jaga.
জগা এরকম the land council for the state has produced two letters. One is dated 25/11/2024 of the Joint Secretary to the government, which relates to premature release of appellant number 1 Joga Proska, and the other letter is dated 26/11/2024. Joint Secretary to Government, the Law Department. এটা হচ্ছে Senior Superintendent Circle Jail Koraput, so that appellant number 2 Hori Praska has been released prematurely by the government. By remitting the unexpired portion of the sentence. The orders are taken on record. The criminal appeal is disposed of. Jail criminal appeal, yeah. Abet nahi, dispose of real out. Mortgage la abet li thanda, but one season to premature. Yes, next.
Item 14.
କଣ ଆଜିରେ ଇନ୍ସପେକ୍ସନ ନବାର ଥିଲା?
Conviction stands.
line ରହୁଛି ନା, if they intend to file challenge this conviction, they can file an appeal. ସେଟା ରଖିଦେଲା, ସେଟା ସବୁଥିରେ ରହୁଛି, ଏଥିରେ ବି ରହୁଛି, ସେଥିରେ ବି ରହୁଛି।
Stigma ତ ରହିବ।
ହଁ, ନାଇଁ ମାନେ ଏଇଟା ଜାଗା ରହୁଛି, ଯେହେତୁ ଡେଥ୍ ବି ହେଇଛି, ଆମେ ଡିସ୍ପୋଜ ଅଫ୍ କରିଦେଉଛୁ। ହଁ ସାର୍, ସେ ଲାଇନଟା ଗୋଟେ ପାରାଗ୍ରାଫ ଲାଷ୍ଟକୁ ରହୁଛି। ସେଟା କଣ ହେଲା, ସେ ବଞ୍ଚିଛି ନା ନାଇଁ, ସେଟା ବେଲରେ ଯାଇଛି ଭାରି, ତାପରେ ଆଉ ଇଏ ଆପଣ କୁହାଯାଇଥିଲା ଇନଷ୍ଟ୍ରକ୍ସନ ନବା ପାଇଁ, Nana Pierce for the Chutti Product and Council for the State 6 some more time to obtain.
ଦେଖନ୍ତୁ ଆପଣ ଫାଇଲରେ ଥାଇପାରିବ, ପୁରୁଣା କେସରେ ଥିଲା ଫାଇଲରେ, ଆଉ ଆଗ କେସରେ ଆପଣ ଫାଇଲରେ ଥିଲା।
ଆଗ ପଛ ହେଇଥିଲେ ଗୋଟେ କନଫ୍ୟୁଜ।
এটা হচ্ছে 2011 মସିହାର ଅପିଲ, ହଁ ସିଙ୍ଗଲ ଆପେଲାଣ୍ଟ ଆଉ କଣ ବେଲରେ ଚାଲି ଯାଇଥିଲା, ତାପରେ ଏନବିଡବ୍ଲ୍ୟୁ ହେଇଛି, ଏନବିଡବ୍ଲ୍ୟୁ ଏକ୍ଜିକ୍ୟୁଟ ହେଇପାରୁନି, କିନ୍ତୁ କଣ ତାର ଷ୍ଟାଟସ କଣ ଏଇସବୁ ବିଷୟରେ ଆପଣ କହିବେ ବୋଲି ଅର୍ଡରଟା ହେଇଥିଲା। ଲାଷ୍ଟ ଅର୍ଡର ଇଜ ଡେଟେଡ 15/9/2025. State Council seeks some time to obtain instruction whether the by virtue of the NBW issued by this court, the appellant has been arrested and produced before the learned trial court or not. That was the instruction. We seek some more time for the. Yes, next.
Item 15.
Information from the soldiers will transfer to CORAM in item 50. So I create some of that which I have already implemented.
Total custody period টাକୁ ଆଣିବାକୁ ପଡିବ ଆପଣଙ୍କୁ।
Lordship had asked for the custody period and criminal antecedents. Lordship had wanted.
The Learning Council for the State submits or seeks some more time to obtain the এটা অর্ডার ହେଇଥିଲା ଆପଣଙ୍କର 1/9/2025 ରେ
So it's central, we not this.
After that, again, it had been
as
discussed.
per the order dated 1/9/2025. Of this matter, so it should be for proposal. Yes, next.
Item 16.
Item 16 matter. Take this case for stay of the relation of fine matter. And the personal religion on bail, right, stay relation of fine. It is allowed next.
Item 17.
This is also bail has been perhaps granted. Yes, stay relation of fine allowed.
Item 18.
The item 17 would be 17 a bail है stay relation of fine पे आसची. We are granting stay relation of fine. Okay. Could have 18.
Yes, may Procedural matter. This is corporation 2015 matter. Sorry. 2010.
Yeah.
This is the Procedural 7/19.
Trial period ala 4 years 8 months. तापर conviction दा होची केते 2 वर्ष केते ABC ala 7 years 7 months.
7 months 19.
ଦି ଜଣ ଅଛନ୍ତି କି? ନାଇଁ ଜଣଙ୍କର ଏ ଦିଟା କଣ ଦେଇଛନ୍ତି ଗୋଟେ ତ ଦବା ଅଛି. So what is the case about?
The conviction is of 2014. Judgment of 2014 matter.
They have not calculated 7 years because 2014 तापरे तो ट्रांसफर कर ले
But you are telling he has never been released by the
just a minute. Yes, Mr. He is right. এটা ଆପଣ ଦେଇଛନ୍ତି up to release date କଣ ଦେଇଛନ୍ତି हे ଲେଖା ହେଇଛି transfer to circle jail ଫୁଲବାଣୀ ରୁ ଆଣିନାହାନ୍ତି and
2017 पर कंटिन्यू करछि ना
हाँ ए कोर्ट बेल देनी तो जदि 2017 तो हेले आपनकर एठी आस जाउछि
15 years.
17 ये 24 हेले 7 वर्ष आवरी गेलानी और 7 वर्ष हेले 14 वर्ष हो जाउछि मोर देन 14 इयर्स देखुछन ना एटा अप टू 2017 पर्यंत कैलकुलेशन तापर लिखा है ट्रांसफर टू सर्कल जेल फुलबाणी पीरियड आपण आनी ना दी आउ ये भी नहीं बेल भी ही नहीं तो ऑब्वियसली 14 इयर्स लाइन
जेल पर
हां
भेजते हैं 2 इयर्स तापरटा दे
हां ये 14 इयर्स लाइन
फुलवाणी वाला सोन तो कल ये तेरे वाला कल कर जाओ
कौन ऑफेंस कौन
May Procedural matter. This is a class of 302 matter. I mean corporations 24/5/2016.
Have you obtained the? Yeah. Your na kono? Gudu alias Kailash Munda.
Yes, ma'am.
ଏଇଟା ଗୋଟେ କାର କଣ ପ୍ରଡ୍ୟୁସ କରୁଛନ୍ତି ଶିବ ଆଲିଆସ ଦୁର୍ଗା ମାରାଣ୍ଡି ଏଇଟା କଣ କଣ ଦେଉଛି ଲୋକ
ଆଉ କୋଉ ମେଟ୍ରୋ ଦେଖନ୍ତୁ
ବଡ ମେଟ
ନେକ୍ସଟ ମେଟ୍ରୋ ହଉ
ରଖିଥା ତା ପର ମେଟ ହଁ ବୁଡୁ ଏଇଟା ହିସାବ କଲେ ଏଇଟା କେତେ ଦିନ ହଉଛି
3402 କେତେ ହଉଛି
ଡିଭାଇଡ କରନ୍ତୁ 365 ରେ
9 years.
9 years
24/16 and 9 years. More than 9 years.
What is the case prosecution case?
I took the disease with me to catch fish mal in the pond. On the next day morning, the villagers found that dead body, and they alleged I confessed before them.
So circumstantial evidence.
Yes, madam.
last scene
Last scene.
Heard the land and complainers. Heard the land council for the petition, land council for the state. Land council for the state has produced the custody certificate of the petitioner from Superintendent District Jail Keonjhar, which shows that the petitioner is in judicial custody for more than 9 years. The custody certificate is taken on record. Considering the submission made by the land council for the petitioner, that the case is based on circumstantial evidence and the main evidence against the petitioner is the last scene.
Yes, ma'am.
Last scene evidence. How confession का पकड़े?
Say villager.
Extrajudicial confession before the villagers. And after hearing the land council for the states, and since there is no chance of early hearing of the appeal in the near future, we are inclined to release the petitioners on bail. Yes.
Stay there some time.
Fine.
296.
296. ଆସିବ ସେଟା ମଗିଲା ପରେ ଦେଖିବେ ସେ ଇଏଟା ଆଉ ଏଇଟା ମଗଉଛନ୍ତି ଇଲେକ୍ସନ ପାଇଁ ତାହେଲେ ସେଟା ଅର୍ଡର କରିବେ
Oblige करे.
ସେ ମଗେଇଦବ ଦିଟା ଗାଈ
Item 21.
ଏଟା ଅନ୍ୟ କଣକୁ ମାରିଲା 501.
question of pass profile certificate ଜାଣିଛନ୍ତି
3170 କେତେ ହେଲା
ଆରେ କାଲକୁଲେଟର ହଉନାହାନ୍ତି କଣ 3170 divided by ସେତେ ହଉଛି 8 years old. 8 years 6 months. बाकी IAC का no criminal antecedent. कौन आसरा जजमेंट रे कहाँ कौन क्वेश्चन थी 302 मिस्टर प्रधान कौन एलिगेशन कौन आई विटनेस सुचंदी ना कौन आई विटनेस किए No, it was an eyewitness to your plan.
Sorry, your lordship, sir. Taking your lordship. Lordship, sir.
Eyewitness.
Go ahead, please, lordship.
No,
Go ahead, please, lordship.
PW5.
It was 5 minutes.
Page 25 रे of the judgment.
Yes, lordship.
Paragraph 16. है
Yes, lordship.
We come to the last 5 paragraphs. 5 and 6 paragraphs. 16 number paragraph of the judgment.
Yes, lordship.
Thus on analysis of the पढ़ो internal page होची judgment रा 25
Aye.
paragraph होची 16
Yes, lordship.
पढ़ो the last shorter line do 10 on analysis from the bottom.
Thus, on analysis of the evidence of the witnesses as above, the following chain of circumstances are established. The deceased Shiva Murmu had gone to the Puruna Pani village for crushing Chuda on 7/1/2017 along with his friend Bironchi Machi. On the return way, the accused and the deceased and Bironchi Machi entered into the exchange of hot words and indulged in fighting. The accused threatened the deceased and his friend Bironchi Machi saying, "Jao mu kon koruchi dekhibo." It was evening at the time. In the same night, the deceased Shiva Murmu was hacked to death with the incised cord injury. The weapon of the offense was recovered an instance of the accused from the place shown by the accused. The weapon of the offense was having faint human blood stain mark. The evidence and the query report of the doctor contains the opinion that the weapon of offense may have been used in the commission of the offense. The motive of the accused was take revenge for the assault on him. All the above circumstances have been fully established. The facts established are consistent only with the height
So
of the
basically, 2 things. One is that threat given, the other is the recovery of the weapon of offense
It-
where
yes,
some
sir.
blood was found.
Yes, Lord, sir. Except
That was,
that is the
and threat because of that fight you gave him threat.
5 has said 5, 6, 7. All three have said that.
খবর কেতে 1806 মাস। Or the learning counsel for the petition, learning counsel for the state. The learning counsel for the state has produced the custody certificate of the petitioner to Superintendent District Jail, Keonjhar, which shows that the petitioner is in judicial custody for more than 8 years, 6 months. He has also produced the report from the IAC Patna Police Station, Keonjhar, to show that there is no other criminal antecedent against the petitioner. The document produced by the Land Council for the state are taken on record. Considering the submission made by the Land Council for the petitioner, that the case is based on circumstantial evidence, and the main circumstances are the threat given by the appellant to the deceased for dire consequences after a quarrel ensued between them, and also a recovery of the weapon of offense with blood at the instance of the appellant. Land Council submits that the petitioner has good chances of success in the case and balance of convenience is in his favor, and there is no chance of early hearing of the appeals in the near future. Therefore, the bail application may be favorably considered. Land Council for the state oppose the prayer for bail. Considering the submission, nature of evidence adduced by the prosecution, absence of any direct evidence, the nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, and absence of chance of early hearing, we are inclined to release the petitioner on bail allowed.
if you will also to communicate to the jail or
TST iteration of order to communicate of passengers for. Yes, next.
Item 22.
It was directed to obtain the wakalat number, already the
Puja holidays. After Puja holidays. As great for the.
Item 24.
I have not received the paper book.
Mr. Mishra and counsel appearing for the appellant submits that though the paper book has been prepared, but receive this state receipt purchase.
Yes.
Let a copy of the paper book be handed over to the land council for the appellant. Look at this matter after Puja holiday.
I filed IF for a state.
Hmm?
State relation finding.
Has to actually state question. Yes, next.
Item 25.
State by Mr. Mishra that an interim application has been filed for stay of realization of fine, which has been registered as IN
297.
297 of 2025. Let the same be placed on record, not be placed after Puja holiday. Yes, next.
Obliged.
Item 25.
25 year lordship has called for the criminal license, custody certificate and conduct inside jail.
Mr. Ponda. Amulya Ratna Ponda. Land Council for the state has produced the custody certificate.
Criminal license and conduct in jail.
And also conduct of the petitioner in jail, conduct of the appellant in jail. Which are taken on record, non-appears for the appellant, put up after ensuing Puja holiday. Yes.
Item 26.
नहीं 24 नंबर भी सेम थिला
Yes.
तो this number will liquidate non-RPS करके आपको पूजा दे तो produce question is you ask for the order dated so on so is produce the custody certificate out on for
Custody CA and
CA jail conduct
conductor.
Item 27.
Petition has received.
अभी filed वकालत नामा ना
Yes, no.
all right prisoner's petition has been received
Also paying for the custody
from jail for engagement of Mr. Prabhas Chandra Jena. The Mr. Jena has filed Wakalatnama, which is accepted. The names of the earlier counsel, engaged counsel, Mr. कहाँ ना कटी हो
B.R. Mahanti and
पीएर महांती पीके राज तारपरे ए महांती को ना रहिबो ना कटी हो ए महांती रहिबो हो
Yes, ma'am.
ए महांती रहिबो ए महाराणा
No, ma'am.
कटी हो
Yes, ma'am.
अच्छा पीआर महांती ना कटी हो बीके राज कटी हो ए महाराणा को ना कटी हो ना स्मृति रंजन महापात्र नाम तो नहीं कटी जाइए ऑलरेडी yes
Also paying for the custody certificate. And this, there was question copy, question copy.
IA number so and so this is an application for bail. Let the land council for the appellant supply the deposition copies of the witnesses to the land council for the state, who in turn shall produce the custody certificate, criminal antecedent and conduct inside jail after puja holidays. Yes, next.
Item 28.
Last procedural. This honorable for the purpose of conduct of the appellant while he was on an interim bail for a period of 4 weeks.
Aschi.
No, there is only antecedent as called for.
Conduct and we interim bail ଯାଇଥିଲେ order dated 3/9/2024 ଅନୁଯାୟୀ ସେଟା ଆଣିବା. The land council for the state has produced the report relating to the criminal antecedent from IIC Sorada police station, which is taken on record. However, he seeks some more time to obtain instruction in respect to the conduct of the appellant while on interim bail as per order dated 3/9/2024. Put up this matter after entering puja holiday. Yes.
Item 29.
May I please? Madam, appellant is in custody since 10/1/2021 minor for committing offence on 376/12 and 376.
Speak little louder.
Madam, appellant is in custody since 10/1.
Miss Anima Dean को देखिले.
Madam, I have
Ready.
अच्छा.
FIR laws occurrence took place on 8/9/2020 minors. FIR laws on 9/1/21 and appellant is in custody since 10/1/2021.
Pokto 6 of the Pokto Act and the
Victim
minor
victim कितने नंबर था की? days ପରେ ସେ ଏଗୁଡାକ ଆମେ ଲେଖିନୁ ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବେ ସେ ବାହାଘର କଥା
Item 30.
item 30 can't take up after puja holidays item 30
Call for the CA and
season Land Council for the state has produced the CA outcome
custody certificate.
custody certificate which have taken on record. Yes, next.
Item 31.
Condition to 302 of the acquisition letter.
Earlier bail application was rejected as it
Yes,
appears
yes,
on 24/11/23.
My lord.
Now, what is the detention period? Custody certificate
It's
ଅଛି?
about my lord, more than
The
40
custody certificate not available.
ନାହିଁ
No.
ନେଇ ଆସନ୍ତୁ custody certificate CA ଆଉ conduct ହେଲା after puja holiday ହଁ
health condition ଭଲ that was also good.
health condition ଦରକାର health condition ଟା ନେଇ ଆସନ୍ତୁ next
Item 32.
My lord, Platform Bail, IN number 847/2025. Offense committed did not sue 307/34 and IPC. Date of occurrence 23/9.
you were granted interim bail earlier
My lord,
on what date
7/10/2024. Release on the bail 3 months. Surrender 21/2024.
what was his conduct during interim bail period obtain that instruction
My lord.
No, my lord. Conduct certificate, custody certificate already filed.
କୋଉଠି ମନା କରୁଛନ୍ତି
No, my lord.
Interim period conduct.
custody certificate ଅଛି surrender certificate ବି ଅଛି conduct report କାହିଁ
Health condition, conduct, etc.
ଆରେ ନାହିଁ ପରା ସିଏ ମନା କରୁଛନ୍ତି ଆପଣ କୋଉଠି କାହିଁ ସିଏ ତ କହୁଛନ୍ତି ମୁଁ ମଗେଇନି ଆପଣ କୋଉଠି ପାଇଲେ
Notice ଆସିଥିଲି.
ଦେଖନ୍ତୁ the learning council for the IN number so and so this is an application for bail learn council for the state seeks some time to produce the report from the through the concerned IIC relating to the conduct of the petitioner while on interim bail as per the order dated 7/10/2024. Hello? Of this matter after puja holidays. The name of Miss Vijayalakshmi Tripathi shall not be reflected in the pause list. Yes, next.
Item 33.
In this case, the jail authority wrongly furnished a custody certificate. In fact, the accused transport to CORAM jail. Compliance affidavit.
ପୁରାଟା ନେଇ ଆସିଛନ୍ତି କେତେ ବର୍ଷ ହଉଛି
9 years,
9 years 3 months
3 months.
ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଥିଲା କି
Earlier ones, it was
Maybe.
in 2023.
6/12/2023.
6/12/2023.
କୋଉଠିକାର ଲୋକ କୋଉଠିକାର
କୋରାପୁଟ
Jaipur.
302 case
302. The cousin sister, taku, in order to get the gold ornament.
robbery ଅଛି
Yes.
Based on the circumstantial evidence, there is no eyewitness in this case.
Part the land council for the petitioner land council for the state. The land council for the state has produced the custody certificate of the petitioner which shows that he is in judicial custody for more than 9 years. And the custody certificate is taken on record. The land council for the petitioner submits that case is based
Also one
on
compliance affidavit filed by the jail superintendent.
complaints update.
ସେଥିରେ ଭୁଲଟା ଦେଇ ଦେଇଥିଲେ ତ ମାଇଲା directed to explain what.
ଠିକ ଅଛି the land council for the state the petitioner submit that the case is based on circumstantial evidence and there is no chance of early hearing of the appeal in the near future, therefore the bail application may be favorably considered. Stop. Land council for the state on the other hand submits that Earlier, the bail application of the petitioner was rejected on merit by the order dated 6/12/2023. Considering the submission made by the land council for the respective parties, nature of evidence available on report, I will not intending to release the petitioner on bail on merit, but taking into account that he is a local person and in custody for more than 9 years and absence of any chance of early hearing, 3 months bail granted.
Item 34.
You are directed to obtain the custody certificate and the criminal incident. Case of triple murder. Triple murder, custody 3 years, 9 months.
And the custody
Yes,
certificate.
my lord.
Land council for the state produce the custody certificate, which are taken on record, put up these matters after Puja holiday. Yes, next.
Item 35.
Certified prisoners petition has been received. SK Dwivedi. You have filed your Okalapna? Yes. Prisoners petition has been received for engagement of Mr. SK Dwivedi. Who has filed the Okalapnama? Okalapnama is accepted. The name of Mr. Prashant Kumar Mishra and his associates shall not be reflected in the cause list henceforth. Stop. IA for bail. कौन कितने वर्ष हेलानी?
Custody since 13/9/2016.
आपको rejected लगी?
No, my lord. Custody has not been rejected.
तो फिर
Case of
certificate
triple
नहीं
murder.
है?
Triple murder.
Based on circumstantial evidence.
That is from after Puja holidays. In the meantime, you will obtain the custody certificate. Yes, next.
Item 36.
Yes, Mr. Jafrullah. आने लगी custody certificate.
Yes, my lord.
कितने वर्ष हुई?
2018 देखो
7 years, 7 months. 7 years, 7 months.
हाँ 22/5/2018.
My lord. Eyewitness is there, my lord.
ये eyewitness
Schedule 4.
PW4 eyewitness.
Leading to discovery also, and Schedule 17 is the doctor.
PW4 child witness.
Yes, my lord.
कौन पूछी?
The child along with his father were sleeping in the night. The child woke up and found the present petitioner was holding a cutlery. The present petitioner, driver of the deceased, my lord, previous driver, develop illicit affairs with the wife of deceased on the relevant day, entering into the house of the deceased, committed murder. Wife of the deceased also
Child-
required.
But child has not disclosed the name of the petitioner.
Yes,
That is the
disclosed.
case. He has not disclosed the name of the petitioner after for the first time.
Ashok after Puja holidays. Next.
Item 37.
Custody certificate produce कर लेता हूँ.
Yes, my lord.
Custody certificate produce taken on the next.
With the lordship's permission, item 35, your lordship called for the custody certificate along with the CMMB called for.
Yes,
Yes. Custody certificate CA produce. Yes, next.
Item 37.
But here I am now, not placing the IN number 853 of 2021.
कौन है जी?
IN number 853 of 2024, I am not placing now.
IN number 853 of 2021. Is an application for extension of interim bail. Mr. Padi, Land Council appearing for the appellant does not want to praise this application. Disposed of as not placed. Yes, next.
Not the IN number 1079 of 2025 for bail. my lord. And
Previously, the bail application of the petitioner was rejected on merit on 24/6/2024. Again, also withdrawn on 12/12/2024.
No, it's all right. Now he has filed another application. You obtain the custody certificate.
Well,
Custody certificate and other things like CA and jail conduct to be obtained. Next.
Item 38.
After Puja holiday. 38, Mr.
May I please, your lordship? On the last occasion, custody certificate was called for.
Unless,
Yes, ma'am.
କେତେ ବର୍ଷ ଅଛି?
10 year 4 months.
Hmm?
Upon 10 year 4 months.
ଆଗକୁ ରିଜେକ୍ଟ ହେଇଛି କି ମେରିଟ ରେ?
My lord, on
Yes.
2/4/2024.
2 for 2024.
କଣ ଅଫେନ୍ସ କଣ?
My lord, there is 302 and 304B and 34 of the IPC.
Double murder. Wife and son.
And my lord, the case is based on circumstantial evidence, and the mother, who is another
And petitioner has also one criminal incident.
ఈ ప్రకారం
506.
wife of who for the
Incident, sorry, eyewitness.
No evidence.
oral material.
Only tangible place. Right. Cause of death is due to throttling.
Throttling କରି ଟାଙ୍ଗି ଦେଇଥିଲା। 10 ବର୍ଷ ରହିଲାଣି।
My lord.
ଛୁଆଟା ଯୋଉ ମାରିଛି କେତେ ବର୍ଷ ହବ?
ଛୁଆଟା
8 ବର୍ଷ mother settlement. IA number so and so, this is an application for interim bail. The number ta huchi 2546 of 25, which has been filed on the ground of ailment of the mother of the petitioner. Medical document ki diye na? Medical documents have been annexed to the interim application. Land counsel for the state submits that he has received the copy of the interim application in court today.
Yes.
And he may be given some time to obtain instruction on the interim application put up after entering puja holidays. Yes, next.
Item 40.
Yes, IA, my lord, for interim bail.
I'll obtain instruction, my lord.
1831.
Yes.
कौन ପାଇଁ bail ରହୁଛନ୍ତି?
ଜେଲରେ ସେ ପଡିଯାଇ ତା ହାତ
ତା ନିଜର ଇଏ
ସେମିତି କିଛି ନାହିଁ।
ମେଡିକାଲ ଡକ୍ଟର
several times were shifted, my lord. Now they
କଣ
are
ଆସିଲା ରିପୋର୍ଟ କଣ ଆସିଲା?
ନା ନା ସେମିତି
ନାଇଁ
ନା।
କଣ କହିଥିବ ଆପଣ ଗୋଟେ କଣ କହିଦେଇଥିବ।
there on petitioner number 2 also is a lady.
ନା ନା ଜଣ କଥା ଆପଣ 1831 ରେ ଆପଣ ନେଇଥିଲେ ସ୍କିନ୍ ଏଲିମେଣ୍ଟ କଣ?
Skin element plus in bathroom, my lord, slip for which
ହେଲ୍ଥ କାର୍ଡ ମଧ୍ୟ ଦେଇଛନ୍ତି along with the report.
ଆପଣ ବର୍ତ୍ତମାନ 1831 କୁ ଆମେ
1831, yes.
1831 ର ଗ୍ରାଉଣ୍ଡ ନେଇଛନ୍ତି ଆପଣ
Skin disease plus ये my lord. ये जो पड़ीगला.
chronic skin patient
Yes.
and not providing any treatment to him. ଆଉ କହିଲା appellant origin bail on during କହିଲା ଆଉ ତ କିଛି ନେଇ ନା ପଡି ଗଲା କୋଉଠି ଆଉ କିଛି ନାହିଁ କିଛି ନାହିଁ ଗ୍ରାଉଣ୍ଡ ନାହିଁ
After filing of this, my lord,
1832
କାହିଁକି ନା ଏଇଟା 21/7 ରୁ ଫାଇଲ ହେଲାଣି ତାପରେ ଏବେ ଆସୁଛି
1973
1973 is for mother, my lord. She is 58 something.
ହଁ ତାର କଣ ଅଛି?
Interim by name, and as he is a lady during trial, she was on bail, and four years already completed.
Suffering from no disease, neither previous history of illness, nor is taking medicine for any disease, as declared in.
एटा लिख देना IA number 1831. This is an application for interim bail, है ना? Filed by appellant number 1, Rusi Karkara, on the ground that the petitioner is a chronic skin patient and the jail authorities are not providing any treatment to him, nor shifting him to the hospital to provide treatment. As for the order dated so and so, the London Council for the state has produced the written instruction dated 31/8/2025 from Superintendent Subjail Nabarangpur to show that the petitioner is suffering from no disease and there was no history of previous illness, nor he is taking any medicine, and he has not complained before the jail medical officer for any disease.
Was shifted to Nabarangpur, then my lord Korapur.
In view of such a report, the health card has also been annexed to the report. In view of such, we are not inclined to release this one. So accordingly, IA number 1831 dismissed. बाकी कौन अच्छी
1973
deposition copy is not served.
I for interim bail for some days because she is a lady.
1973 और 1832 of 2025
tक
sterilization of fine allow कर दें. 1973 is an application for bail of appellant number 2. नाडा लिखी देवे.
Champarani Corporation.
The London Council for the petitioner submit that the petitioner is a lady and she was on bail during trial and she has remained in custody for more than 4 years.
4 years, yes.
9/8/21 ରୁ 27/3/23 ପର୍ଯ୍ୟନ୍ତ UTP, thereafter after conviction.
You just obtain that custody certificate. The Land Council for the state shall obtain the custody certificate. He further submit that he is not having the deposition copies with him. Let the Land Council for the appellant provide deposition copies to the land council for the state after ensuing puja holiday.
I have the deposition copy right now I'm supplying.
हाँ तो କହିଦେଲୁ ଆଉ କଣ ପୂଜା holiday just अब ପାସୋରି ଲାଗି